I paid for my green card from 6th of February. I came into the USA on the 14th of February. I've not received my green card yet. It's over 120 days. What kind of advice can you give me? There's not a lot of advice I can give you at this moment, other than you can make an inquiry with immigration. Call the 1-800 number, see what they have to say. Everything's a little delayed right now because of coronavirus. You should be getting it momentarily, but certainly contact the 1-800 number. That would be the first place I would go, see what they have to say. Let's see what else we have here. Sweet ex-theorist. She has not showed up for a while and comes right in with an immigration question. For a friend, she found out she's in a bigamist marriage. She adjusted her status, but asked her lawyer to withdraw the petition. Question, can she void her marriage? Does she have to go and get it annulled? Secondly, she's been married to this U.S. citizen nearly 2 years as an overstay in the USA. What can she do based on her situation? Well, if you're in a bigamist marriage, you're not married to him. It's a void marriage. I would get an annulment just so when you go back to immigration, there's no question that you were in a bigamist marriage, and therefore you're not showing up with your next husband, and they claim you're in your friend's in the bigamist marriage, and your friend would say, no, my husband was in a bigamist marriage before, so therefore that marriage was void, and it becomes very complicated. So I think the best thing for her to do is get an annulment and get a judge to void her marriage, even though it's void by operation of law. There's only one thing you could do when you're in a bigamist marriage. There's two things you can do in a bigamist marriage. You can get your spouse to get a divorce and remarry your spouse and then apply for the green card. Or two, if that marriage is kaput, then you get the annulment. And if there was abuse, if there's abuse, then you can file a VAWA even in a bigamist marriage. Otherwise, you would need to get married again. And by the way, I just got notification that was the correct post. So let's see that post one more time. That is the free consultation post. Find that post. I guess we put up the same post 2 times in a row because that was the same post from the week before with the confetti cannon. So I don't know why we have the post 2 times in a row, but we do. So find that post, tag 5 friends, and if you do, you can get involved in next week's immigration free consultation giveaway. All right, let's see what else we have here. Jesus Hazen with a question. Hey, Uncle Brad, I'm filing the I-864. My wife is a U.S. citizen and doesn't meet the minimum requirement. She's a full-time student, is not working, so we're using a joint sponsor. Do we still have to fill out the parts on the form asking for employment and income, even if we are using a joint sponsor? She has not filled taxes. We don't have these documents. Thanks from the DR. All right, let's read this one more time. I'm filing my I-864. My wife is a U.S. citizen and doesn't meet the minimum requirements. She's a full-time student and is not working. Yes, you still have to, and the question is, do we still have to fill out the parts on the form asking for employment and income, even if you are using a joint sponsor? Yes, you fill it out and you say not employed. You fill it out and say not employed. And I've now received 25 text messages from Jilly saying I'm not correct. It is the same. It is a different post. I hear you, Jilly. It is a different post, a different color. One was teal, one was blue. To me, it looks like the same exact post. But Jilly says one's teal and one's blue, so be it. All right. So let's continue to the next one. Niak Einkun. Good evening, team. My question to you is, my priority date is July 5th, 2012. How long is the wait? Thanks in advance. Only thing I have available is the first letter I should be getting anything as yet. I don't know who filed for you, Niak Einkun. Were you filed for by a parent? Are you single? Are you married? If you're single, let's assume you're single and you got filed by a U.S. citizen, excuse me, and you got filed for by a U.S. citizen, then your priority date is current. You should be hearing from the National Visa Center. If you are married, then you would not hear for a few more years. Even if you were single and filed for by your permanent resident parent, you should have heard something from now. So the answer is, if you're single, you need to contact the National Visa Center. If you are not single, the priority dates have not been reached yet because your priority date is July 5th, 2012. I just don't know who filed for you to give you the right answer. Let's see what else we have here. Loki Sam. I didn't receive my extension letter after filing my I-751 jointly. Can I still file for the N-400 when my 3 years hit? Still married? Yes, you can. As long as you know that the extension is pending, you absolutely can. Just because you don't have it doesn't mean that they don't have a record that you filed for the I-751. Let's see what else. Pradeep Ram. Uncle Brad, sorry for the long question. My lawyer filed on October 2018 VAWA, and it's been 20 months since I filed. I provided police clearances for the last 5 years from the UAE, New York, and Texas. Recently, USCIS updated my status as undergoing background checks. Please tell me your opinion. How long does the background check take? The background check shouldn't take more than 12 months. If it is now 20 months and you're still in background check, at that point, I think you need to contact me and we need to start thinking about filing a mandamus or threatening to file a mandamus to force the government to do their job. 20 months since you filed an adjustment application and your case is still in background checks, that's a problem. So I would give me a call if you choose to. Brad, this is from Cher Topaz. Brad, I'm contemplating getting your summer books, but it pains my heart to waste my money on these unscrupulous people. You know, I was just talking about that with Jilly. So like for John Bolton, for example, I bet you somebody's going to put that book online for free. And you'll be able to find it for free somewhere. I bet you. So don't go spend money on John Bolton. Taser Jadalhack. Hi, my wife for 20 years was a permanent resident from 2000 to 2005. Then we left out of the U.S. for my job and we stayed for 123 years. 1 second, you didn't stay for 123 years. Let me read this again. My wife for 20 years was a permanent resident from 2000 to 2005. Then we left the U.S. for my job and we stayed out for 23 years. You wrote 123 years. I assume it's 23 years. I filed the I-130 again for her overseas and she got the permanent resident status again. We came back to the U.S. on January 2019. When can she file for her citizenship? She can file for her citizenship in January 2022, 3 years after she got her conditional green card back again, or a permanent green card back again. Wouldn't be conditional, it would be a permanent green card back. So in 2022, 3 years from then. It has nothing to do, Taser, with how long you've been married or how many children you have. What it has to do with is how long has she had her green card, and she got her green card in January 2019, so you got to wait 3 years. Todia Gunny Christopher with a question. My friend had married a U.S. citizen and was told he had to go back, and he did. It's going to be 10 years next year. When did she start filing for her husband? Well, why did he go back? Was he deported? If he was deported, what was he deported for? So if he was just deported because, when I hear I had to go back, it sounds to me like he was deported. So if he was deported for fraud, then he needs a waiver. If he was deported for being here illegally for more than a year, he needs a waiver. If he was deported for criminal activity, he may or may not be eligible for a waiver. When should she start filing for him? Now. Why not? But before she starts filing for him, let's figure out why he got sent back. And then we can figure out what waivers are available before she goes and wastes her time spending money and effort to go file for him. Brad, my husband is a Canadian citizen. What do I file? Are you asking to go to Canada? I have no idea what you filed to go to Canada. If you're asking that you're a U.S. citizen and you want to file for your husband who's Canadian and he's in Canada now, you would file an I-130 visa petition. Kristen on YouTube prior to the show said, I'm a resident, but my status of residency is abandoned. I want to come back to the U.S. Well, if you abandoned your permanent residence, you got to start over from scratch. You got to figure out a new way to get a green card. Kamar Solomon asked a question about a day ago. If I have a criminal background from my home country, theft, I went to court, I paid a fine, no time served, do I have to file an I-601 when adjusting? It depends what the maximum time for that theft offense was. If the maximum time for that theft offense in your home country was 1 year in jail or less, then it would be considered a crime of moral turpitude, but a petty offense. You would not need a waiver. If in your home country, if the judge wanted to throw the book at you and put you to jail for the maximum, and the maximum was more than 1 year, then yes, you would need a waiver. So we got to figure out what the law was in your home country. Ruhal Marwaha has a question. Hi, I'm from Nepal. My parents are green card holders. They applied for my F2B category February 2019. When can I expect my green card? About a while from now, about 4 or 5 years from now. The I-130 was approved. My wife is petitioning for me. I'm the husband. I'm outside of the United States. I recently received a letter from the National Visa Center. We are required to fill out an affidavit of support, but my wife does not meet the minimum income requirements. She's a full-time student. So we are using a joint sponsor. As it explains on the instructions, we still need to fill out one for her own, as she's the petitioner, and a second one for the joint sponsor. Correct. Even if your wife is not working, she needs to fill out the I-864 affidavit of support. Now, she has been unemployed for the last 2 years, and she has not filed taxes. On the I-864 form, there's a section for employment and income. Is it okay to leave those parts empty as we have a joint sponsor? Or do you have any suggestions? Just write not employed. That's all. Don't leave it empty. Just write not employed. All right. Kamar Solomon asking the same question. Theft charge in home country, no jail time, paid fine. What are the odds of adjusting? I answered that question. It depends I need to know what the actual penal code was in your particular country. What are the required documents to use a house as an asset on an I-864? Well, the required documents are you need to prove who owns the house, so title to the home, and you need to know what the value of the house is after the mortgage. Thanks for watching. For more Brad Show Live, like and subscribe to our YouTube channel.